Hello. Today's topic is Industry Unbound, the inside story of privacy, data, and corporate power, which is also the title of a new book by Professor Ari Waldman, who is joining me today. Hi, Ari.
Hi, thanks for having me.
It's such a pleasure. I'm looking forward to this conversation. You are a leading authority in law, technology, and society, and a professor of law and computer science at Northeastern University, where you also direct the School of Law's Center for Law, Information, and Creativity. You're widely published as a scholar, including the book Privacy as Trust, Information Privacy for the Information Age, and the new one, Industry Unbound, the inside story of privacy, data, and corporate power. Um, Before we go into the book and why you wrote this and some of the premise of the book, where are you joining us from today?
I'm here in New York City. You can see in the background a little bit our half of our art wall in in our apartment. I teach in Boston, but the Northeast corridor easy enough to commute back and forth.
Very good, very good. So what's the book's central argument?
So this book is based on nearly 4 years of fieldwork inside technology companies, mostly in the United States. And its central question is, how can it be the case that every day, and we're still seeing this, there are new technologies and new products brought on the market, glasses that have video cameras, apps that track your emotions, websites that gather information about where you're moving your cursor. Right, exactly. How is it that we can have all these new products coming out, yet at the same time, people say that we have all these new privacy laws, the GDPR in Europe, the California Consumer Privacy Act here in the United States, 11 new proposals for comprehensive privacy legislation in the United States Congress, and we have tens of thousands of new privacy professionals whose job is always supposed to be protecting privacy or advocating for privacy on the inside. So how is it possible that we have what people are telling us are all these new, strong privacy structures, yet at the same time, our privacy seems no better protected on the ground? And the book explains that the corporate structures of big technology companies, medium technology companies, and even startups are able to co-opt both law and people toward serving the ends of data extraction, such that even people who come into their work thinking that they're privacy advocates, they end up serving the corporate goals in the end. There's a almost false consciousness among many privacy professionals, engineers, salespersons, and so forth. They don't even realize that the work they're doing is actually undermining our privacy.
This is fascinating and something that I see every day in my work with data and working with companies. And also as a consumer, you experience this all the time, that you consent to things that you don't understand. The terms and conditions are much too long for anyone to read. So your book is based on 4 years of field work, interviews, and so on. How did you gain access to organizations, and what did you learn from the process?
In some cases, I didn't gain access to organizations. Companies like Facebook and Google explicitly said that either, in Facebook's case, that they're not interested and won't allow me to talk to any of their employees. And Google said the only way that we're going to talk with you is if you talk to these set of people, and we only speak to you on deep background. And actually, Facebook and Google said that we need prior approval of any quotes and any literature or any scholarship that you write as a result of interviewing us. And that's not just a bad idea, but that's also a violation of research ethics. So for companies like that, gaining access is really hard, but there are other ways. There, you can meet current and future employees, and I did this at conferences, whether they're law conferences, privacy conferences, engineering conferences. You can meet them through what sociologists call snowball sampling, which is you get introduced, or you have certain people in your network or in your colleagues' networks who do this kind of work, and they introduce you to others. And although only doing that kind of research isn't sufficient, it helps you gain a foot in the door, so to speak. So in some cases, when companies were recalcitrant or didn't want access, because they're all very secretive about the work that they do, I had to take other more aggressive measures. Other times, there were companies that were really excited about giving access because they thought that their privacy programs and their designing for their processes for designing for privacy were really good. So I had the opportunity to be embedded inside several medium-sized tech companies that were designing apps or products while I was there. Of course, I didn't get to see the entire life cycle of some of these products, but to sit in design meetings, to walk with engineers to their desks, to see how they do their work, to speak with privacy professionals and lawyers, that was a really great opportunity. I did it on my own dime, raising money through grants, so I wasn't beholden to the companies I was researching. And all of that put together, as well as reviewing documents and something that researchers called interface ethnography, which is when you can't gain access to a company like Facebook or Google, sometimes these companies have these public or invite-only events where they present some of the work that they're doing to scholars and advocates. And although you can't quote, the rules are if you go, you can't quote the individual, but you can still, they're based on Chatham House rules, so you can't identify the person who spoke, but you certainly can use that information. So there's a combination of tools that I had to use, and that's why it took so long, because it was hard to it's hard to pierce this veil. But in the end, even though what I did find, interviewing 121 people, reviewing stacks of documents, and so forth, and witnessing or being embedded inside 3 companies, that doesn't speak to every single company out there, but it does speak to a narrative that exists.
Very good. So if you could sum it up, what's wrong with current privacy law and protocols for new privacy laws in the US?
So pretty much all of the privacy laws that we have today are roughly the same, and that includes the GDPR and the European Union. They all combine a series of individual rights, like you have a right to access your information, you have a right to ask a company to delete it, you have a right to transparency, all those kind of things, and some more broad than others. And then there's a series of compliance requirements where companies have to keep records, and they have to do audits, and they have to complete privacy impact assessments, essentially putting the companies themselves as the leaders or monitors of their own work, subject to a regulator asking for that information. The problem with that is that those compliance systems that our companies create, they don't exist in a vacuum, right? They're not their own separate entity that are designed to do the work as the legislature intended. In fact, they're part of a larger organizational system. And when they're part of a larger organizational system that the company creates, it's really easy for companies to either hobble the office or more commonly, I found, to create this sense that even though an individual privacy professional or engineer thinks that they're advancing the cause of privacy, it turns out that they're not. So for example, a privacy professional may be doing a lot of work, right? They might spend hours and hours doing the work that's assigned to them and writing reports and writing down policies. But if all of their work about privacy is focused on giving us more buttons to click, more buttons to agree, more toggles to click, and more privacy policies to read, people tend to confuse the amount of work that they're doing with the actual substance. So it turns out that a law that requires the companies themselves or requires companies to create internal structures is essentially giving companies the freedom not just to capture the regulation of the law, but also to undermine the way the people who see themselves as privacy advocates actually do their work. So that's a design flaw in the law, one might think. But another way of looking at it is that this is exactly what corporations want. As you and I both know, legislatures, whether they're in Brussels or in Washington, D.C., tend to listen more to wealthy corporations than they do to you or I. So it stands to reason that it's much easier for corporations to get into a law the things that they want, as opposed to the things that privacy advocates might want.
Yeah, so do you think this is all a sinister plot on the part of companies and privacy professionals? Are they trying to undermine privacy purposefully and a bit like a storybook villain?
I think there are some of those people. Like it's hard to look at Mark Zuckerberg in the news and not think that he's just evil. But there are stories of heroes and villains are much more common in fiction, and they're less common in reality. In fact, I don't think Mark Zuckerberg or any executive or any privacy professional or any VP of design comes into work and says, I am going to destroy privacy today. There are some people, I'm sure, that don't care about privacy. But I think what they do is they come into work thinking, I want to make my company money, or I want to do the best that I can do, or I want to have a voice with my boss. They come into work with these pretty anodyne, pretty normal goals. But because they are working inside structures that are designed to make money off of data extraction, then it's very easy for all of those goals to be co-opted into a larger goal. So is it villainy? Is this some kind of grand plan that some white dudes in a smoke-filled room thought up a long time ago and they started the information age? I don't think that's the case. I think it's more of a series of small decisions that executives and structures make to advance an otherwise understandable goal like profit. But in the structures that they've created in the world that we exist, all of that turns into a system of co-optation or a system of subordination where not just we're the victims, but also privacy professionals are the victims.
Yeah, it's interesting. It's a concept I've never really thought about until you said it, that actually putting some of these laws in place means that you then create big departments. You can say you're doing lots of stuff, everyone looks busy, but actually it's not really helping a lot, because data nowadays is such a valuable asset for organizations that is driving growth, is driving profits, is I would argue is the most important business asset of today. So getting this right is difficult, and at the same time we've seen this in lots of organizations. They have done very well by ignoring or trying to sidetrack laws to get their hands on data to deliver better products and services, which then customers love. So it's an interesting dilemma.
Right. And it's not unique. You're 100% right. And I don't think it's also unique to privacy. So a lot of these structures exist in other areas of law. So we hear a lot, companies tell us a lot about their work trying to include or take account of diversity. Right? We hear about diversity and inclusion. Companies create diversity offices. Universities create diversity offices. And then a lot of those offices turn into, here's a policy, here's an event. Here's someone who's just going to be the face of our office, and let's put them in marketing tools. Also, when companies are required to comply with non-discrimination rules. Here in the United States, and here I'm relying on the work of the sociologist and lawyer Lauren Edelman, who's a professor at Berkeley. Here in the United States, we have a law called Title VII, which is a provision of the Civil Rights Act that says employers can't discriminate on the basis of sex in hiring, and promotion, and so forth. And that law was passed decades ago. That law was passed in the 1960s, and yet boardrooms and executives and workplaces are not. They're somewhat better, but they're not appreciably better. There still is extensive discrimination in the workplace, and Professor Edelman described that the reason why that's the case is because instead of actually applying the law, instead of actually complying and not discriminating on the basis of sex, instead what companies do is they create organizational structures that make it look like they're doing that, and then weaponize those structures against people, against women, against people who want an opportunity. And that's almost exactly what's happening in privacy. It looks really good when a company hires a privacy office, when a company hires privacy lawyers, when they even hire an engineer and say, you're going to work on privacy. But then once you hire a privacy office, it's very easy never to listen to the privacy officer. It's also very easy to silo privacy professionals from the work of design. So, for example, several of the companies several of the companies in which I was conducting field work, as well as other companies that I learned from through interviews, there are lots of companies that require the engineers who are working on new products to either answer privacy questions on their own, like ad hoc, not that they or their managers, who also are engineers, are trained in privacy, but also they prevent lawyers and privacy professionals from affirmatively and take the initiative to go to engineering teams on their own, and in fact require privacy questions to trickle up. But you can imagine that only the weirdest or the strangest or the worst privacy questions are going to trickle up if they do at all, and B, the things that most of the decisions are going to be made by engineers or by product managers. And if you keep those two groups separate, things are going to get missed. And also it keeps people who may be better capable of spotting privacy issues out of the system of design. And yet at the same time, the lawyers don't realize that. They don't realize they're doing their work. They're addressing what their teams need. They're writing privacy policies. Engineers are doing what they're hired to do, fix problems, solve really cool engineering problems. And yet subtly, companies are using their reporting structures in order to minimize the effect that privacy can have on design.
Yeah, fascinating. So what was the craziest story or the craziest thing that you've learned or saw during your research?
Wow, well, there are so many absolutely bananas things that I learned during this research. I'll give you one good example. So I was sitting in a meeting with a general counsel, privacy professional, and several associate privacy attorneys at a company that mid-sized company, and as I've mentioned, or as I haven't mentioned in this conversation, I haven't been mentioning a lot of the names of these companies, except for companies that have refused to speak with me because I signed confidentiality agreements or guaranteed a lot of my interviewees pseudonymity so they could speak honestly. So one of these companies, a mid-sized company, had actually been involved in some privacy litigation, meaning that their general counsel and their attorneys had written and signed briefs in cases where users, a particular case where a user had challenged their dissemination of particular information that they shared online. And the argument that they made was, in this brief, was that once you disclose something on our platform, you don't have any privacy rights in it. Right? We've seen that argument before because you've shared it. You've lost control over your information. Remember, we talked a little bit ago about it doesn't matter how much work privacy professionals do. If their definition of privacy is one that eviscerates privacy, it's not going to help. So this company had made that argument in court, and that's fine. If a company wants to make that argument to achieve the best outcome for its client, that's fine. So I was in this meeting with them and asked, so do you feel, here's your privacy policy, and they spent about a half hour telling me about all the ways that they care about and protect our privacy. And one of them said, we have extensive privacy protections that allow you to share information on our platform and keep it private. So I asked, so your policies and your systems are set up to protect people's privacy even after they disclose information? People said yes. And then I asked again in another context, so if I shared X and I showed it on on a screen of their platform, if I shared X using this setting, you would consider this protected, or I would still be able to protect this as private. Yes. So when I showed them the brief that they had signed, the people in the room had signed, and I showed them, well, how can you make this argument in court? The general counsel stormed out of the room, didn't even say anything. He stormed out of the room. And as he was walking out, he said, "This is a witch hunt." And then one of the attorneys said, "Well, that's just our zealous advocacy for our employer, which all lawyers are supposed to do." So in a sense, you had someone who was just being a petulant child, even though he was a 65-year-old man. And you had the rest of the team saying that they lie about their privacy rules and their perspectives on protecting our privacy interests under the guise of being an aggressive advocate for their employer, as if that justifies lying to us about our privacy protections.
That's crazy. So why are we stuck on this path of more of the same privacy laws?
I think there are a lot of policymakers that don't realize this. That's part of the need, I think, for this book. And I've worked with some policymakers before, and I've sent them snippets of this book and the book itself. Hopefully, there'll be some realization that the system isn't working. So, but setting aside the fact that I don't think people really understand this, because a lot of it is happening inside, there is a certain path dependency that we have here. This dual system of privacy law that I mentioned earlier, the individual rights and the internal compliance, those aren't new. Individual rights when it comes to privacy are decades old. In the 1970s, the US Department of Health, Education and Welfare, which is now the Health and Human Services Department, published a report saying that here are some principles about privacy. They're called the FIPS, the Fair Information Privacy Principles, or Fair Information Practice Principles. And they list pretty much all of the same individual rights to data, that you have a right to transparency, that you should have a right to access, that you should have a right to security, all of those things. And compliance requirements, those are also decades old. The European Union had the privacy directive since the 90s. And the directive, even if they were recommendations as opposed to requirements, the difference between a directive and a regulation is that a regulation is binding as it is on all the countries. A directive, different EU countries can adjust on the margins. And also there's a difference between the provisions and the recitals. But in the directive itself, there were compliance requirements. The Federal Trade Commission in the United States had been requiring compliance responses to investigations since the early aughts, since the early 2000s. So we've been doing this for a really long time. But instead of these requirements coming down from policymakers who have the interests of consumers at heart, not all of them do, but instead of that happening, privacy law has percolated up from the bottom. It is what a sociologist of law would call endogenous. Is the law has developed from the practices of industry on the ground. So it stands to reason that the law is going to be helpful and beneficial to industry. But it's put us, because these things have been happening for so long, individual rights, compliance requirements, because these are decades old, it's almost as if people can't envision what privacy law is other than that. And that's something that I found so often in my research. When I was interviewing people and they would talk about the things that they're doing to protect privacy, and they would say, well, we're very transparent about what we do with our information. And I said, well, why not just not collect information about sexuality, which you don't use? And they say, but that's not what privacy law is. Or when I would say, well, why don't you design this system to automatically delete data after a year? To automatically delete the data collected after a year. And the response I would get, well, that's not what we have to do. That's not what the privacy law is. As if they couldn't imagine, A, that they could do something more, or B, they couldn't imagine anything else other than what they've been doing. Path dependency and habituation, those are really strong forces that keep us from seeing other options.
Yeah, so you talked about people designing or engineering the system. Is it their fault that we're getting these privacy invasive technologies? I guess some would argue that engineers don't have the best track record with caring about privacy, right?
That's true. I mean, we see that a lot. Engineers are not trained to talk about privacy. They learn about security, like keeping a system secure and designing cybersecurity protocols. But privacy is not a huge part of their education. Those things are changing, but it's very chic. It's very common. It's very popular to blame engineers for a camera in a pair of glasses, because engineers are not thinking about privacy. They're thinking about more ways to collect data, more ways to get new forms of engagement. But engineers don't operate in vacuums. Engineers are not kings of castles or run their little fiefdoms without someone telling them what to do. In fact, engineers have to do what their product manager tells them. There are VPs of design who create the rules, or there are people in charge who say, design this. There are structures that put them in small teams that say, your job is to answer this small this small engineering problem. There are 20 other teams that are working on this big project. You don't care, don't focus on any of that. In fact, we're not even going to tell you what these other teams are doing. You just focus on this. And that's actually, for some engineers, that's exactly what they want. There's a lot of psychological studies and sociological studies done about engineering and design teams. They're often at their best when they have a specific job to do and they're working on it in a small team. But when you enforce ignorance and when you require them to achieve a goal of engagement, right? More clicks, more time on a website and so forth. Well, it's not their fault that and they end up creating a product that invades our privacy. They're just doing what they're told and not given the opportunity to do anything else.
So how can you start fixing that? What are some of the things that organizations could do differently? Do they need to change their business model? What do we need to do?
Yeah, there have been a lot of lawyers and organizational experts who have proposed lots of different solutions to these problems. So maybe we need new laws. Maybe we need laws that aren't just individual rights and compliance. Some of my colleagues have suggested that we need laws, what we call fiduciary responsibilities, which mean almost like the kind of responsibilities that lawyers and doctors have toward us. They have to care for us, and they can't benefit. From us while benefit themselves while hurting us. Some of those, there are also other recommendations of a new privacy agency in the United States, other than the FTC, or more money at this, or or things like, thinking about privacy as a civil right. If your data is used to discriminate against you, then you have a right to sue. All of those changes, they seem really good, right? All of those changes seem really good, and they seem like they would fix some of the problems. But if you think about them go one step deeper, they just perpetuate the compliance problem. Because if you create a law, if you make a law that says companies have a fiduciary responsibility to us, like doctors or lawyers, well, they're just going to create compliance departments to ensure a duty of loyalty or a duty of confidentiality and so forth. So there's still always going to be compliance departments. If you have a new privacy agency, you either better give it like $1 gazillion to deal with these companies who have gazillions of dollars, or they're still going to rely on internal privacy compliance or governance. So a lot of these changes or reforms around the corners or on the margins of this system, I'm not sure that they're going to work, or at least I'm cynical about whether they're going to work. So my vision or my hope for the next step, and here I have to admit, I'm still working this out. Even books for an academic are still works in progress. I think we need a more emancipatory approach to what privacy law should be. And what I mean by that is privacy law should be structured not as a system that allows companies to innovate within certain limits. In fact, I think privacy law needs to be structured as an overt and obvious counterweight to corporate power. Like, that has to be our goal. We have to see it as our job to not just pick at the margins, but to undermine a business model that is based on the commodification of human experience. So that's the goal. But how we do that is really hard. My model here is Andre Gorz' idea of non-reformist reforms. Andre Gorz is a French Marxist philosopher or social philosopher. And his idea of non-reformist reforms was that a reformist reform is like picking around the edges. So to take an idea that's in the popular mindset today, a reformist reform would be putting an accountability office inside a police department that has a history of abuse, right? That's not going to do much, right? Because it's easy to co-opt. A non-reformist reform would be shifting funding from the police, away from the police to social workers or mental health workers to deal with homelessness, for example. That's a non-reformist reform. It doesn't solve the problem of over-incarceration, but it gets us toward that goal. So I think privacy law needs to get down to the nitty-gritty and regulate the business model that we've created here. Just because we exist in an information age where companies make money by extracting data from us doesn't mean that we have to continue to exist in this environment where the idea of innovation is an excuse for just doing anything that these companies want us to. So what that means in detail, I'm still trying to work out, but what I do know is that we need a very different orientation for how we think about and how we write about privacy.
Fascinating. So you mentioned that you've done this research, you've written the book, but this is still work in progress as always. So what kind of research did you not get to do, or what would you have liked to see and love to do?
Wow, there's so much. So you asked earlier about access, and access was a real problem in this project. I had to do a lot of work, and it took a lot of time to get a better picture of what's going on in some of these companies. But one of the things that I would really like to do is, in addition to getting more access to some of these companies, is I would love to understand the evolution of companies from startup size to big size. So, and that I didn't have a really great opportunity to look at, because interviewing venture capitalists was even harder than getting, I think, through the phalanx of Facebook public affairs people. Also, there are tons of startups and there are tons of investors in new technology companies. It's hard to even know who to speak to. So there are parts of this business model that still need research. Another area that I didn't get a chance to focus on were the intimate connections between these companies and governments, right? So it's one thing to be concerned about how companies use their structures to undermine civil privacy law, to undermine consumer privacy law that we deal with. It's another thing to understand and be concerned about how these companies take that information and then give it over to a government law enforcement agency whenever that agency wants. We're hearing this now about things called geofence warrants that have been sent to Google. A geofence warrant is kind of like, here's a warrant that requires Google to give over information about where we have been using the geo-tracking that a Google program or a Google device has done over a certain period of time. Essentially, giving us a offense, putting us give law enforcement an idea of where someone is and what they're doing. The idea that we work with and use Google devices with the expectation that that information is just going to be granted to government whenever they ask for it, I don't think that's something that we expect, right? So that's another area that I haven't had the opportunity to research. But the next thing that I want to research is how these affect marginalized populations. How does the undermining of privacy inside companies not just affect us all, but the unique conflict points that, say, for example, queer people face? As a gay person, I'm particularly interested in how technology has been a source of trouble and subordination for queer people.
Yeah, they're fascinating fields of research, and I guess so far your research has focused on the US, right, and a little bit on Europe. I guess there are huge differences in other countries as well, if you then take China into account and other countries where
there may very well be, and there's ample research opportunities for people who have connections to and have connections to China, can speak the language, have access to corporations there, who understand the legal dynamics of a somewhat capitalistic, somewhat central planned economy. There are privacy laws all throughout the world, in addition to Europe and Israel and South Africa, in Brazil, there in India, right? So there are also political dynamics here. How can governments that are in the media uses kid gloves to call them populists, but how can governments like nationalist and anti-Muslim governments like in India, how do they marshal state connections to technology companies to surveil farmers and to surveil Muslims and to surveil marginalized populations? I mean, we know the Modi government is doing that, but there is a desperate need for additional research into how governments that are hell-bent on subordinating minority populations are using their intimate connections to technology companies to do so.
Yeah, lots of issues to resolve. So what are your future hopes and predictions for the field of privacy and corporate power?
Well, I am a little cynical, and when I say that, people often respond that I'm too young to be cynical, but in the world that we're living in now, I don't think anyone is too young to be cynical. Every day we wake up and something bad is happening, or even outside of the fires that are sometimes literal and often figurative fires that are happening outside our windows. The problem is this path dependency that I was talking about earlier. It's hard to break habits. Like, it's hard to break habits in our personal lives, whether it's drinking coffee or smoking or drinking or whatever. It's hard to break those habits. So here you have an entire political and economic system that is based on habitual performances or habitually performing privacy and accountability. How are we going to step out of that when our electoral system, especially in the United States, is completely broken and gives a small minority in this country outsized voices? Well, I'm not sure how. I think one of the ways that we should start thinking about changing the information economy is not thinking about, we need to pass a privacy law. We do need to do that, but passing a privacy law is not going to do anything unless we also have more robust anti-competition law, unless we also get rid of political gerrymandering, unless we make it easier for people to vote, unless we fix the undemocratic electoral college in the United States, unless we shift the tax burdens and ensure that the wealthy and corporations pay their fair share, unless we have environmental protections that are going to make it harder for these big tech companies to upset delicate ecosystems, and they bury wires and tubes under the ocean in order to transmit data from continent to continent. All of these things are part of what make the information economy what it is, and our 30, 50-year neoliberal project of letting companies basically do whatever they want has led us to a world that we exist in today where it's hard to imagine anything else.
Very good. There's definitely another book or two or three in there.
Yeah,
Thank
for
you
other
so much.
people to read, right.
I really enjoyed this. Thank you so much for your time, Ari, and hopefully we will have a follow-up conversation at some point soon.
Absolutely. Thank you so much for having me, and I appreciate all of your insightful and really wonderful questions.
Thank you.